Put the gun down. Gun down.
Welcome back to Advocacy, Alchemy with Professor Ross. Today we have a good one, guys. Today we have a thought-provoking case to talk about. A traffic stop in Jacksonville, Florida that ended with a man accidentally being shot in the leg by a female police officer. The officer, attempting to remove the man's firearm, mishandled it, resulting in the discharge. It's clear this was more of a Barney Fife moment than an act of true malice. Since then, the officer has been fired and the man has filed a civil lawsuit. Was this an act of negligence or was it an unavoidable accident? Let's break it all down.
I appreciate it, man, being very honest.
yeah.
You okay? Hey. Put the gun down. Gun down. You okay? You got shot in the leg. Rescue 1068. HQ 2162. Rescue 1068. 1020.
Yeah.
Yes, sir. Where's your pistol at on you?
On my side.
Okay. Just put your hands on the top of the vehicle for me. I appreciate it, man, being very honest.
yeah.
Oh, you okay? Put the gun down. Put the gun down. You okay? No. Hey, Rescue 1068. Let's go. He's very compliant. He does have a pistol on him, so we're gonna think about. Where's your pistol at?
On my side.
Okay. So put your hands on top of the vehicle for me. I appreciate it, man, being very honest.
yeah.
Oh, shit. You okay? Hey. Put the gun down. Put it down. You okay? Nope. Yeah, John, thanks. Rescue 10.
In this short video, captured from 2 body cam angles and compiled by the New York Post, we see the tense moments of the traffic stop unfold. The footage begins with the officer asking the man to place his hands on the vehicle. As she attempts to secure his firearm, the gun discharged, hitting the man in the leg. The man's reaction is immediate, a mix of shock and pain, and the female officer appears startled as well. Let's analyze this further in the context of Florida law and the implications of her actions. Several legal concepts and potential charges apply in this case. Let's explore them. First, you have negligence per se. All right, this occurs when someone violates a law or regulation designed to protect the public, and that violation in turn causes some harm. Here, firearm safety protocols and departmental policies may serve as the basis for a negligence per se claim. If the officer mishandled the firearm contrary to her training, it could constitute negligence per se. Now, we all know to become a certified law enforcement officer, you're going to receive firearm safety courses. Number 2, ordinary negligence. Ordinary negligence requires providing evidence that the officer failed to exercise reasonable care. The plaintiff, the man who was shot, would argue that removing the firearm in a careless manner caused the injury and that the harm was foreseeable and preventable. That means that an ordinary reasonable person would have foresaw removing that firearm in that fashion is probably going to cause it to go off. Number 3, battery. Let's talk about civil battery. We've talked about criminal battery in the past, but there is a thing of civil battery. It's a tort. Civil battery, when looking at the officer's actions, you're trying to determine if her actions were reckless, even if unintentional, leading to a civil claim for harmful contact. Battery is just an unwanted touching when you define it as a tort. You're going to sue somebody for touching you, or, usually something like spitting on you, or, but fighting, hitting you, shooting you, all those apply. Now let's move into criminal battery. Now, if prosecutors find her actions grossly negligent, we use the word grossly, this means very, very large, or reckless, they could pursue charges, though intent would be difficult to prove. Number 4, criminal negligence. Florida law defines criminal negligence as conduct showing reckless disregard for the safety of others. However, criminal negligence charges are unlikely the same as above because the officer's actions, while careless, they don't really rise to the level of reckless disregard required under the law. The officer's actions, they just may meet this threshold if her firearm handling is deemed to pose an unreasonable risk. Number 5, unavoidable accident. Now there is a concept that's interesting. The officer's defense may argue that this was an unavoidable accident, looking back at the possible external factors like maybe some abrupt movement from the victim or a firearm malfunction. However, the man would probably counter that if she had proper training, it should have prevented incidents like this. Let's talk about the evidentiary standards. Evidentiary standards are the levels of proof required to establish facts in legal proceedings. Here's a brief description of each level followed by examples as they relate to this case. Number 1, mere suspicion. The lowest standard referring to a hunch or some unverified belief. It's insufficient for any legal action, but it might prompt the officer's initial attention. For example, the officer initially noticing the man's firearm on his hip may have raised mere suspicion that further precautions were necessary. Number 2, reasonable suspicion. This is a belief based on a specific and articulable fact that criminal activity may be occurring. This justifies a temporary investigative stop. For example, the officer's reasonable suspicion of potential danger justified her attempt to secure the man's firearm. Number 3, probable cause. A reasonable belief based on facts and evidence that a crime has been committed. This standard is required for arrests or searches. For example, the officer's actions in detaining the man and disarming him would need to meet the probable cause standard if they were to lead to charges. Number 4, preponderance of the evidence. This is the standard used in civil cases, meaning it's more likely than not that the claim is true. 51% of the evidence needs to point to the claim being true. For example, the man who was injured here must show that it's more likely than not that the officer's negligence caused his injury. Number 5, clear and convincing evidence. This is a higher standard requiring a firm belief or conviction in the truth of the claim. Remember, this is about 75%, and this is often used in cases involving recklessness or fraud. For example, if the plaintiff argues the officer's actions were reckless, they must meet this heightened standard. So they're saying that basically if he brings this claim and says she was reckless, he may have to show 75% of the evidence that he puts in there points to her being reckless. Number 6, beyond a reasonable doubt. This is the highest standard requiring near certainty that a person is guilty of a crime, and this is used in criminal cases. For example, to convict the officer of criminal battery or negligence, prosecutors must prove her gross misconduct beyond a reasonable doubt. Let's move into the jury perspective. Imagine if you are a jury member hearing this case. What questions would you want to have answered? One important point to consider is that civil juries in many states, including Florida, can have fewer than 12 members. In fact, in Florida, civil juries typically consist of 6 jurors, except in certain cases like eminent domain, which require 12 jurors. Eminent domain is when they take property, when the government takes property from you, land. This smaller jury size, 6 people, can influence deliberations and dynamics when assessing cases like this one. When you have a small jury, it might be easier for them to come to a decision quicker. Here's the questions. Did the officer's actions align with her training? Was the firearm's discharge truly unavoidable, or could a reasonable officer have prevented the discharge? How credible would the victim's claims be, and how credible are the officer's defenses? These types of questions highlight the complexity of assessing liability and determining whether there's negligence involved or if this was an unavoidable accident. This case highlights the importance of proper training, the complexities of firearm safety, and the legal ramifications of law enforcement's actions. Whether this incident will ultimately be deemed negligence or an unavoidable accident will depend on the evidence presented and the arguments made in court. Remember, this is Advocacy Alchemy, and I am Professor Ross. Comment below with your thoughts on this case. Please like and subscribe, and I'll see you tomorrow. Everyone have a good day.